Okay. Hi, everyone. Welcome to Tzedek's presentation, Legal Pitfalls in Homeownership and How to Avoid Them. To begin with, I just want to make some introductions. I'll let you know who I am. My name is Amy Williams. I am the Directing Attorney of the Homeowner Protection Team at Tzedek. Tzedek, in case you haven't heard of us, we're a nonprofit legal service and we've existed for 49 years and we provide free legal services to vulnerable communities in Los Angeles. We provide a range of different legal services, not just for homeowners, but specifically our team assists low-income or elderly homeowners in Los Angeles County. And as I mentioned, those services are free for those who are eligible. So today's presentation is going to take about an hour, but there will be some time for questions at the end. This presentation is really about how to avoid common problems that we see our clients face, hopefully through greater understanding of your legal rights and obligations as homeowners. Please note that we're talking about residential homeownership only today and in the California context, specifically in Los Angeles County. And we're doing this presentation in November 2023. I like to think of this presentation as a first aid course. Just like first aid, it's important for you to understand the basics so that you know how to diagnose a problem, prevent further harm, and know when you need to seek professional help. This is the same, but for your homeownership interests. And part of this presentation really is to encourage more people to seek help. If we think about an instance of first aid, say a situation where someone has a broken leg, that's not a situation where you're unlikely, if you see someone with a broken leg or someone in your home has a broken leg, to wait to get assistance. But unfortunately, issues of financial security and to do with homeownership are not treated in the same way. Let's be frank, we don't like talking about money. There is a stigma and sometimes a certain amount of shame around the idea of needing help with financial problems, with not being able to provide for your family, or not meeting your responsibilities related to your home. Unfortunately, we find that that prevents a lot of people from getting the help that they need. And just like with common medical problems, there are very few problems that can't be resolved or at least addressed if you seek help at an early stage. So in the same way as if you were to see someone with a serious medical injury, like a broken leg, we hope that this presentation and the availability of our services, which are free and confidential, will encourage more people to get help early. So what we'll be talking about today, really briefly, this presentation is, we're going to start with talking about the basics of home ownership. Specifically, anyone here who is a homeowner, at some point you received a document and maybe signed a document that called a deed. We're going to start with the words on your deed and what exactly they mean in terms of your rights and obligations as a homeowner, because understanding that can help you make better decisions about some common problems that a lot of different homeowners face. Some that we're going to be talking about today: property taxes, home improvement contracts and loans, and also estate planning, are things that all homeowners at one time or another consider. We're also aiming at the end of the presentation to provide everyone with a list of resources of public agencies that you can get more information about the particular issues that we're going to be discussing today to help yourself. A quick disclaimer: today's presentation will be general legal information. None of the information that I provide you here today should be taken as legal advice about your specific circumstances. To give someone legal advice, any lawyer needs to know and understand the specific facts of your situation in order to make a full assessment, and that's not something we're able to do today. The information we provide today is about you helping yourself to identify a problem and to know when you should speak to a lawyer. So getting right into it, if we think about property ownership or ownership generally. We tend to think of ownership as black or white. You either own something or you don't. When in actual reality, ownership can take a lot of different forms, entailing different rights and responsibilities. Legally speaking, and conceptually speaking, we're taught to think of this instead as a bundle of different rights, which, depending on the words on your grant deed that granted you ownership in the first place, and also the choices that you may make over the course of your ownership, you may trade or give away for certain different reasons. And the list of the bundle of rights is on your screen. Getting into those a little more deeply, starting with one of the most obvious, the right of control. So this is what being a homeowner is all about, being able to control your home. That means that you can build and change or renovate it as you like. It also means that you can borrow money against the home or get a mortgage. But as we know, all rights exist in balance with obligations. And so even though you have a right to control and do what you want with your home, there are certain laws or rules out there, such as code enforcement laws or zoning dictating the kind of use of your property, or if you have a condominium, your HOA rules that limit your ability to control your home. So that's a good example of when rights exist with obligations or limitations. Second one on there, right of possession, also very obvious. If you own your home, you get to live in it. What that means is if you choose to rent out your home, that's a right that you may be giving up, even though you still own the home. The right of exclusion. This means you can kick other people off your property, put up fences, but another way that that's sometimes limited, or you may have obligations to someone else, is in the event of an easement, which means that you have to let other people pass across your property for certain reasons, or maybe utility lines to pass underneath. Your right of enjoyment. This is about your home being your sanctuary, your place of safety, and your place of privacy. But again, most of us have neighbors, so we all know that your right of enjoyment of your home and your ability to maintain your peace and safety and quiet is often limited by your neighbors and what their actions are. So in the same way, your infringement on their rights of enjoyment is an obligation that exists alongside a right. The legal term for that is called nuisance. And then the right of disposition refers to selling or transferring your home, whether for money or deciding what to do with your home after you pass. Okay, so transfers. Real property transfers, and transferring a property is the legal terminology for when the ownership interests pass from one person to another. The usual way that that happens is through a document called a deed. Now, there's a couple of different words here that have a plain meaning in English. We all know what transfer means. We think we know what delivery means. Maybe we know what interest or recording means. But in the context of real estate law, these words have a specific legal meaning that we'll get into a little bit. So I just want to highlight that. Also, a quick plug that if you ever have any difficulty or come across words that you're not sure what their meaning is, the California Department of Real Estate website has a really useful glossary that can explain a lot of the legal terminology. Okay, so transferring interest to someone else, transferring ownership to someone else through a deed usually involves two aspects. The first aspect is when you sign the document and you give it over or deliver it to the other person. That's the physical act of saying, I'm giving my property to you. The second aspect is the recording of the deed or other transfer instrument. And that's because in our legal system, we have a public property recording system where all of the property across the county are recorded in a public register. The effect of that is to put other people and the rest of the world on notice that you are the owner of your property or of any other interest that any other person has in the property. The kind of deed that you have also often indicates the kind of interest and nature of the transfer. And some different deed names you may have seen include a grant deed, which is the common word for selling a property, a quitclaim deed, which indicates a kind of deed where there are less promises and warranties made about the kind of property or the condition of the property. A deed of trust is the kind of deed that you see when someone takes out a loan. And then a reconveyance deed is the terminology for a deed that when the loan is paid off, the interest that was held by the bank is returned to someone. So those are some common ones that you might see and what they mean. Okay, getting into pie. It's Thanksgiving, so we're going to talk about pie for a little bit. And pumpkin pie, because why not? So thinking about pie and ways to split up the pie is a really good way to think about what different ways of ownership or holding title means. The list that you see on the screen, the first one, a sole owner, that one's really obvious. If you're the sole owner, you are an individual and you own the property. The others on the list there, tenants in common, joint tenants, owning in a trust or owning in an LLC, are different common ways to hold property. They're not the only ways by any means. And they basically mean that it's different ways to split up the pie. We're going to start by looking at joint tenancy versus tenancy in common. And this is basically two really common forms of owning property with another person, or with perhaps more than one other person. It doesn't even have to be a person, it can be another kind of entity, but essentially there's more than one owner. Joint tenancy and tenancy in common are two different conceptual ways of owning property with someone else. And the easiest way to think about it, if we start with tenancy in common is like owning shares of the property. You can have more than one and they can own different kinds of shares, usually expressed as a percentage. And that person's share of ownership as the tenant in common corresponds to the responsibility that they have to also pay for the property and contribute to it. By contrast, a joint tenancy is not seen as owning in shares. All of the joint tenants or all of the owners own the whole property together. So we think of joint tenants as kind of one unit that owns the whole property equally and also contributes equally. The other main distinction between joint tenancy and tenancy in common is the way that the property is disposed of or the rights of disposition. So the big one here is with joint tenancy, if one other person or if one of the joint tenants passes away, the property goes to the other joint tenant. And that's something that's automatic. And it's something that often occurs outside of the probate process, which we'll go into a little more later. By contrast, tenancy in common, the share that any one tenant in common owns, in the event of that person's death, doesn't necessarily pass to the other tenants in common. It passes to the heirs of that person. I do want to make a quick note here. We're talking a lot about the word tenant. When I say tenant, I don't mean a tenant like you rent someone to. That's just the word that's used in place of owner here. And there's a historical significance to that. The other thing to note here is that each of these different ways of owning property with other people comes down to the specific words that are put on your grant deed. If there are no specific words saying how you own property with someone else, then the default is that you're tenants in common. Okay, the second way we're going to talk about holding property here is holding in a trust, contrasted with holding through a corporate entity like an LLC or other kind of corporation. Now, I'm not talking about these two in terms of them being in contrast or alternatives to one another, because they don't have to be, and either of these arrangements can be a good arrangement for a homeowner, depending on what their particular needs are. We're talking about this here because this is something that we get asked about a lot, holding property in a trust or the benefits of holding a trust. But it's helpful to know what that actually means. So a trust is when you create a document. So a trust is usually a document that's created that splits up who gets to benefit from the property and who manages/owns it. When the property is owned, it's being held in trust, it's being managed by the trustee for the benefit of whoever is named as beneficiaries. And you can have beneficiaries right now at the time that the trust is created, and also in future. So a trust is an instrument or a tool that people often use to do estate planning as well. So there can be present beneficiaries and future or conditional beneficiaries. The easiest way to think about this in terms of pie is that one person takes care of the pie and the beneficiaries get to eat it. The key thing to note here is that a trust is not a separate entity. It's the trustee who's responsible. And the other thing that a lot of people do know about trusts is that holding property in trust is a way to avoid the probate process after someone passes. By contrast, owning property through a corporation or LLC, a corporation is always a separate legal entity. That means essentially you've created a fictional person and that person owns the property. There can be different members or owners of the corporation itself, and those people may change. There may just be one owner or member of a corporation, or there may be multiple. And whether those human owners change or not doesn't change the ownership of the property by the corporation. The other main benefit of owning property through a corporate entity is that it limits the liability of the humans behind the corporation. Okay, now we've talked a little bit about title records and deeds. And so just a quick note about how you can access and find those if it's something that you want to look into, or it's something that you ever need to look for. All of our property records, as I mentioned, are held or maintained by the county recorder's office in Los Angeles or by county, essentially. In order to access the title records for your property, you usually need to know your parcel number, which is sometimes called an APN or AIN. And just a quick note here that there's a program that was actually set up by the county recorder's office to access people's title records for free, called the Homeowner Notification Program. It's set up in cooperation with the county assessor's office. It's an anti-fraud measure. So if you sign up for the Homeowner Notification Program, which if you're a homeowner in LA County, you're entitled to do, they'll send you a free copy of any time that your title changes. Other than the Homeowner Notification Program, there's a small fee for accessing copies of your title records that are maintained with the LA County Recorder's Office. Some of them are available online, and others, if they're older, you have to go to the office in Norwalk to get a copy. Just a quick note that when you see the slides with a list of resources along the bottom, we're going to provide a list at the end of the presentation with links to how to access those resources and reminders of what they actually are. Okay. So we're going to consider a short scenario here, and I'm going to ask someone else, one of my colleagues, Taylor, to read this for us.
All right, thanks, Amy. Anna owns her home in her own name. She intends to pass it on to her two children, Sunny and Cher, when she dies. Anna is about to undergo surgery. She transfers her home to Sunny before the surgery in case she passes away, and so he can help her during the recovery period. She wants to avoid costs and probate, and she can't afford to do a trust. She understands there's a tax exemption for parent-child transfers. If she survives, he agrees he will transfer it back to her. What might happen?
Thank you, Taylor. Okay, before we get into Anna's scenario, it's important to go over a couple of basics about property taxes in California. So firstly, I want to clarify that what I'm referring to are the property taxes that come twice a year in the form of a bill. We're in property tax season right now in November. Your property taxes may be paid directly by you, or you may pay them through an escrow account with your mortgage servicer, if you have an escrow account, something that's really common. In any case, the amount of property tax that's paid on a home is based on the assessed value of the property at the time of a transfer. Now, the value of a property is calculated by looking at the value of the land and then also the value of any improvements on it. The big thing to know here, which many of you are probably already aware of, is that Proposition 13 is really set up how California's property tax system operates now. There are many other places in the world where your property taxes are calculated based on the market rate, or the market value of your property, which means if your property values go up, your taxes go up as well. It was in the 1970s that Proposition 13 was passed, and that changed the California system broadly from a market-based system to an acquisition-based system, which means your taxes on your property are based on the value when you bought it or when it was transferred to you, plus a small percentage increase per year. It's important to note on top of that, that there are certain kinds of properties, as well as certain kinds of persons or certain kinds of transfers that may be exempt from a tax reassessment, even though a transfer takes place. And just note that exemptions may be something that's applied automatically or may need to be claimed through filing of a form. Now, sometimes you hear the word assessment and also the word appraisal. Appraisal and assessment are slightly different, but both are done by the county assessor's office. An appraisal is something that looks at whether the value of the land or improvements has changed and dictates an increase or maybe a decrease in the property taxes. Sometimes that can happen after a disaster or if there's new construction. But an assessment is something that happens and is triggered by a transfer. I will note that the LA County Tax Assessor has a really useful website with something called the Real Estate Toolkit that has a lot of information about this if you're looking for more. The main question here, thinking about Anna's scenario where she transferred her property to her son, Sonny, in anticipation of a surgery that she was going through, is what might happen with her property taxes because of that. Now, the big question is, does her transfer qualify as a transfer for the purposes of reassessment? And the first thing I want to say here is that this is a very big question. It's not a simple question, and we're only going to be able to go over the basics here. It's a very complicated area of law, and so that's why this is an area where, yes, it is best to talk to an attorney before you do anything to make sure there are no unintended consequences. The tax assessor website, as I mentioned, does have some common kinds of property transfers and can be a guide about whether or not it will trigger a reassessment so that your taxes go up. So, notably, in Anna's situation, we don't know how she transferred her property to her son. And in fact, the different kind of transfer that she does and whether an exemption applies will dictate whether or not her property taxes go up or not. Essentially, the basics of whether a transfer of property will trigger a property tax assessment depends on the degree of change of the ownership interest being transferred. Yeah, that's a mouthful, but she owned her property as a sole owner. We know that. If, for example, she transferred the property from herself as a sole owner to Sonny as a sole owner, that is a complete change of the ownership interest, and yes, that will trigger a property tax increase or reassessment. However, if she just transferred part of her interest in the property, say she transferred a share of the property, or she transferred it to create a joint tenancy, that may or may not result in a property tax reassessment. The creation of a joint tenancy normally does not result in a property tax increase. Furthermore, even if she did transfer the property she may be able to get an exemption because she transferred it to her child. But the quick thing to note here is that it's not just any transfer from a parent to child that qualifies for an exemption from reassessment. You have to satisfy certain conditions. There's sort of a list of conditions. I'm not going to go over all of them here, but the big one to know about with parent-child transfers is that the child has to actually be living in the property or agree to live in the property after it's being transferred in order to get an exemption. And we don't have enough information here to know whether that's occurring or not. The last thing to note here is, the other thing that she wanted to know is can she ensure that the property will go to both of her children after her death? And again, that really depends on how she transferred the property to Sonny in the first place. If she transferred her entire interest over to him, then she's lost any kind of control to dictate what happens to it. If she transferred it into a joint tenancy with him, then the automatic provisions transferring the property to the other joint tenant on her death will mean that her daughter, Share, will not receive a share of the property. No shares for Share. So essentially, what we want to think about here is not just what she's doing right away, but also what the future consequences are and what rights she may be giving up. And what Anna was really looking to do here was a form of estate planning. Now, estate planning is something that we all have to think about it at some point in our lives. And it's really something that it's not one size fits all. It has to be done individual to the person because it depends on what their wishes are and also what kind of assets they have. You may think, when you hear estate planning, you may think wills and trusts. But I want to just highlight that there are some other tools that can be used for estate planning that you may not be as familiar with. Yes, creating a trust, which we know from Anna's scenario, she mentioned that she didn't think she had the money to do that, is one way to plan for your property after your death. Putting your property in a will or dictating what happens in a will is something that you can also do that will represent and make sure your wishes get done, but it is something that does go through the probate process, unlike a trust. The third one on there, beneficiary designations, that doesn't deal with real property necessarily, but it's something that you may already have access to through bank accounts or insurance policies where you can dictate who you want to receive the money contained in those policies or accounts upon your death. There are certain kinds of real property deeds, some of which we've already covered, that have automatic transfer provisions that don't need to go through a court process. And then the last tool on there, POA, which is short for power of attorney, is a tool that you may have heard of before and is something that might have been really useful to Anna in this situation. She was looking for someone she was looking to express her wishes about what might happen while she's still alive, but was incapable of perhaps managing her affairs. And that's something that a power of attorney can be really useful to do and doesn't entail needing to transfer any kind of property. So digging in just a little bit deeper into estate planning, generally speaking, it should be tailored to the individual person, but usually the objectives are always the same. The biggest one that we hear about is that people want to avoid costs. And usually what that means is you want to avoid having to go to court, namely the probate courts, which most estates have to pass through if there aren't provisions or probate tools in place to avoid going through the probate court process. That can take some time and can cost money. But there are other goals as well. Estate planning is something that you do because you want to make it easier for your family upon your death to deal with what you leave behind. Also, you may wish to protect vulnerable family members, including children, and quite often you just want to have a say in what happens. Thinking back to what Anna's goals were in terms of planning for her property, Her transferring the property prematurely to someone in order to avoid costs in estate planning may actually cause more problems down the road and actually increase the costs or burden on her family later. She mentioned, for instance, that she didn't think she had money to do a trust, and that may be the case. However, unintended consequences from property transfers can end up costing your family members or yourself more money because of increases in property taxes and other problems that crop up, and may actually end up costing more money than it otherwise would have to plan things out. So this is an area where it is best to talk to a lawyer for help if you're thinking about making any kind of transfers or you're thinking about doing estate planning. And I do want to mention here that Tzedek has a new estate planning project that is being launched soon, and you can check our website for more details if you're interested. Okay, we're moving on to a new topic. This one is about home improvement loans. Now, before I get Taylor to read the scenario that we're dealing with, I just want to explain a little bit more about what this is about. Home improvement is the greatest thing about being a homeowner. If anyone who owns a home knows that at some point you want to make a repair, you want to renovate, it's part of who we are. We want to control and improve our environment. So much so that we even have a whole TV channel dedicated to this. Now, home improvement loans are the kind of loans that often come with a home improvement contract. Sometimes they are offered by the contractor themselves or set up by the contractor themselves. And this is notable because it's an area where, unlike other kinds of conventional loans through regular banks, we see that there are sometimes less consumer protections, but also a pattern of more kind of predatory practices. And that can include signing people up for loans that require them to pay more than they can afford, or where there's just straight out illegal practices like stealing money or defrauding people. This is not new. This is something that we've seen going on for decades. And I really think it is something to do with this idea of the certain excitement or desire to do home improvements and have the best for your family can allow us to be preyed upon by unscrupulous actors or just make decisions that are not always in the best long-term interest. So this is an area that we really want to highlight extra caution. So Taylor, if you wouldn't mind, let's see what's happening here.
All right. Anna's approached by a salesperson about getting solar panels to lower her electricity bill. She's low income, and they tell her there's a government program that covers the cost, so it's free. It sounds like a good deal, and she signs up. Soon after, she gets a notice that a document was recorded against her property for the solar loan. What happened?
Thank you. Okay, so before I go on to the next slide, I want to acknowledge that there's a couple of different kinds of solar services that exist. We can tell just by the facts here that this is the kind of solar contract where she ends up owning the panels because she gets a loan from them. There are other kinds of solar services where you lease the panels. That's not what we're considering today. I also want to mention, before we go into some of the things to consider when it comes to solar panels, is that we don't want to tell you not to get solar. There are many good reasons to get solar panels on your home. They can range from wanting to reduce your electricity bills to being concerned about fossil fuel consumption in the future, or to improve the value of your home. And there are people who have many good experiences with solar panels with reputable salespeople and installers. Remember, we as attorneys, we hear about the bad experiences, not necessarily the good experiences. So the point of this presentation is for you to learn from and benefit from other people's bad experiences to know what to look out for. The first point is whether solar panels will be a good investment or reduce your energy bills depends on whether they are tailored for your home usage home or energy usage and whether they are properly installed. Installed also means whether they are permitted and attached to the grid. That seems really obvious, but just digging into it a little bit, you or I could go out and buy, for instance, a new table for our home, for our dining room. That's something that any of us could do. We can measure our dining room, and if we have a small dining room, none of us are going to go out and buy a 20-foot table for 12 people. That's just not something that we would happen. Common sense would dictate that. When it comes to solar panels, however, we don't always have that same degree of knowledge or ability to be able to tell what's good for us and what's going to work. So we have to rely on other people, including the solar salespeople who have the electrical engineering background, to be able to get the right thing for our own specific circumstances. How do you do that? The main thing is, like with anything else, to do your research. That may mean getting recommendations from a friend, but a really easy thing to do is to check whether the door-to-door salesperson or the solar contractor that you're talking to is licensed with the Contractor State Licensing Board, which is a California entity. You can look them up by their name, either their individual name or their company name, and see whether they have any complaints against them and whether they're currently licensed. You should not use a contractor who's not licensed in the area that they're looking to help you with. The other thing to mention here is that we see a lot of advertising about solar panels being free. I'm sure you've seen the same billboards on the freeway that I have. The thing to know is that, yes, while there are some free programs out there that pay for the panels, most of these programs are in the form of a tax rebate. What that means is, unless you have a tax bill that's a certain amount, you're not going to get that saving. So this is where a lot of lower income homeowners who don't pay a lot of taxes lose out because they don't ever get that benefit of the free tax rebate. The final thing here is that there are broadly two kinds of loans when you get solar panels. One that can be recorded, both can be recorded against the property, as in Anna's case, and we don't know exactly what happened with her here. But there's one recorded against the property, but it's recorded specifically over the panels themselves, which means if you don't pay your loan, they come and take away the panels. There's other kinds of solar loans, specifically often through the PACE program, where the loans are recorded against the home in the form of a tax lien. And if you don't pay those for your loan, then they are able to come and foreclose and take your house to pay for it. So it's helpful to understand which kind you have if you're getting into solar panels. The other thing to watch out for are any kinds of hidden penalties that may exist if you were to choose to take the panels off your home, or if you had to sell or upgrade something, because that's sometimes where hidden costs come in that are not obvious at the first instance. Okay, while we're talking about PACE, I just want to highlight that this is another common form of home improvement loan that exists right now. PACE stands for Property Assessed Clean Energy and is often touted as being a government program. What I will mention is that although it is a government program in the sense that the county tax assessor's office enforces the loan through a tax lien, there's otherwise not really any more government involvement. Notably, when you hear government program, you think that maybe government is going to be checking that the repairs are being done or that there's going to be some oversight. That is not the case with PACE loans. I will also say, as you may have just sort of guessed, that these kind of loans can be very complicated, unlike a regular loan, because they do involve the property tax system. It's not a stretch to say that this is an area where there have been problems with homeowners not getting what they paid for or paying more than they should have. And so just know that because of the amount of different entities involved, when things go wrong, it can be difficult to resolve issues. And these are loans where there typically is a high interest rate. And we unfortunately do see a lot of inflated prices for repairs. This often happens because you don't pay anything up front. When you pay through your property taxes, you get the repairs, and then your bill comes at the time of your property taxes, maybe 6 months or maybe a year later. So if what you think you are getting is different from what you actually agreed to in writing, you won't actually find out until 6 months to a year later. And that's where we see a lot of problems occur. The other thing to know is that if you have a mortgage and you're thinking about getting a PACE lien, this can lead to a lot of problems with your mortgage servicer because the PACE lien is usually given priority over your mortgage, and servicers generally don't like that. So if this is something that you are thinking about, again, there have been good experiences with PACE, but do your research and make sure you know what you're signing. As a quick overview, here are some quick do's and don'ts, specifically about any kind of home improvement loan, and specifically relating to those that are sold door to door or sometimes at Costco or Home Depot. The first thing is, and it's actually the third thing on this list, but please don't believe what they tell you verbally. It doesn't matter what they say to you. They can promise you the world. What matters is what's actually in the written contract. And this is where we sometimes see problems because quite often these contracts are not in hard copy, not on paper, but they're through, you sign them through an iPad or an electronic contract. Now, it sounds really simple to do that first one. Don't sign anything without reading and understanding it fully. But that's more challenging when the contract is on an iPad, which is being held by the other person. It's very easy to sign on an iPad by just clicking a couple of buttons. So really insist on getting a copy and taking your time to read it, even if it feels weird or awkward. Also, don't feel pressured into signing something quickly. PACE loans have been around for more than 5 years now, and they're not going anywhere. That's usually a sales tactic if they're trying to get you to sign something quickly. And a big red flag is they may need an email address for you in order to get you to sign off. Don't let them create an email address for you. That's a big red flag because if that happens, you're essentially giving them the power to sign things on your behalf, including to sign the contract where they get paid. Okay, some quick do's. As we mentioned, do your research and look up the licensure of the contractor that you're dealing with. Do make sure you get a copy of anything that you sign, whether that's an email copy or whether that's a hard copy. And that relates to this, do remember the 3-day right to cancel. For most home improvement contracts that are sold door to door or at Costco, there is a 3-day right to cancel from the time that you receive the contract. So once you insist on your copy, once you actually receive it, read through it. If it doesn't seem right or if you're not sure about it, remember that you may still have the right to cancel. If in doubt, best to speak to someone or cancel it and try again later. And obviously, this is an area where if you're unsure, it is best to talk to a lawyer for help because most of these loans are years, if not decades. Committing to something that doesn't suit you can burden you and your family for quite a long time. Okay, our last scenario here. Taylor, please go ahead.
Sure. Anna, she's having a long day. She's anticipating that she may have trouble making her mortgage due to changes in her household income. To address this, she wants to rent out the second floor of her home to make up the difference in her monthly budget. She's trying to decide between renting to a family friend long-term or renting on Airbnb. What should she consider?
Thank you, Taylor. Okay. So this situation is a little bit of a trick question. I will say that, because I'm not sure that Anna is asking the right question here. Anna is dealing with, she may have an income shortage soon, and so she wants to rent to make some extra money so she can make sure she pays her mortgage. The question is not whether she rents on Airbnb or to a friend for a longer term lease, but whether she knows what she's actually getting into by becoming a landlord. Now, the items on this slide about becoming a landlord are just some things to think about to make sure the decision is right for you. The first one, and this may seem obvious, but you're giving up the day-to-day control of your home, because any lease that you grant to a tenant means that they have exclusive right and possession to enjoy your home, your rental property. Now, that's a big deal, particularly if you're still living in the home, because it can result in an arrangement where you're sharing with someone. The second thing to know is that though Anna is thinking about increasing her income by making some money off a spare room or a second floor of her property, it may also cost her. And so becoming a landlord can be an investment. The increased cost may involve increased water or electricity because of more people using the home, as well as registration and inspection fees to comply with local tenant laws, and repair costs. And repair costs is a big one, because going to the third point, becoming a landlord can lead to increased risk of liability. Owners of the home, if they rent to someone else, are always responsible for the condition of the home and any injuries that may result. Just like if you sell someone a loaf of bread, the loaf of bread has to be good to eat. If you buy a loaf of bread that's moldy, you're taking that back and you're getting your money back. A home to rent has to have the minimum living standards dictated by California law, and those may not be the minimum living standards that you have in mind. The law can be quite strict around this, and it's notable that this is a non-delegable duty. What that means in essence is that even if you hire a plumber to fix the leak in your tenant's apartment, you're still responsible, legally speaking, if the tenant is injured by some kind of plumbing problem. The tenant will not sue the plumber, they will sue you. The non-delegable duty means that it's ultimately your responsibility to make sure the plumbing works correctly, even if you hire someone else to do it for you. The last thing here is that just to flag that there are a lot of responsibilities with compliance with tenant laws, which can become quite complicated and can limit the rights that you give or the freedoms that you have to manage your home. Going into that really quickly, when it comes to tenant protection laws, this is too big of an area for us to go into in any detail. But the main thing to know is that California has seen a trend towards increasing protections for tenants. And that's because, one, we're in a housing crisis. I know that you all know that because you see the results of that as well. And two, because in the eyes of the law, there is a power imbalance between landlords and tenants. Even if you're a mom and pop landlord, the landlord is always seen as the superior party or the more powerful party between the landlord and tenant, because the landlord's the one that's making money off the situation, and because the landlord has the ultimate control over the property. The increase in legal protections for tenants has led to a very complicated regime, which means that there are protections for tenants from being evicted from homes, and also from having the rent raised on them by a certain amount, and for providing certain kinds of amenities. Those laws that apply can vary depending on the city that you're in. They can vary depending on the kind of building that you have, including the age of the building and whether it's a single family or multifamily, and even by the individual tenant themselves, and depending on the length of time they've lived there for. Notably, most California or many California and local tenant protections override what you might have written in a lease in your individual arrangement with your tenant. So it's important to keep that in mind. And lastly, and this goes back to Anna's question about whether she rents on Airbnb or privately, just note that if a tenant stays for more than 30 days in your unit, it doesn't matter whether you rented them to them on Airbnb or through a private lease. The result is the same and they may have the same legal protections. So this is a big flag to say it's best to talk to a lawyer to know what you're getting yourself into, and so you know and understand what laws apply to you. And this is also a point to say, this is not to discourage you necessarily from renting out your home. There can be a lot of good arrangements, and sometimes you're not thinking about, I want to make money. You're just thinking about giving someone who needs a place to stay, a place to stay. And that's a very admirable a goal, and it can be a very mutually beneficial arrangement, both financially and by having a new neighbor or a new person that you can live alongside. This is not to discourage that, it's just to mention that you should know what you're getting yourself into, because most of our clients that come to us tell us, I never thought this would happen to me. So the main things for Anna to consider in this situation is, what rights is she giving up and what laws to apply to her if she takes on a tenant? Will it actually result in an increase in income, and what kind of rent does she have to charge in order to cover any increase in costs? And just going back to that original issue, if she's looking or anticipating a shortfall in income and inability to pay her mortgage, does she even need to become a landlord to fix that problem? Or is there another way that she can look at fixing the issue or renegotiating her mortgage or filling that gap? This is an area where we often suggest people speak with a housing counselor. Housing counselors are a free service that can help you do an assessment of your financial situation and anticipate any problems, let you know what kind of programs you may be eligible for, and suggest financial solutions or make a financial plan. Now, the resources listed on this screen for landlord-tenant resources, there is a California resource, but note also that most cities or some cities have specific tenant laws. So you may want to check with your local city resource about what tenant laws apply. In the county, there is a useful website that gives a lot of information for landlords looking to rent. And in LA City, the housing department has a lot of information and even training sessions for people who want to be a landlord or understand their obligations better. We are at the end of our presentation. What we wanted to share with you here is a list of local resources. Sorry, not just local, state and federal resources that govern a lot of these issues that we've been talking about today, where you can get helpful information to help yourself and understand whatever kind of predicament or issue you're facing. Not just information, but a lot of these agencies have investigation power and complaint resolution power. So if you're not ready to get an attorney or you want to find out more information or resolve some kind of issue, there may be a resource that's already available through you through a free public agency. And lastly, if you are in a situation where you do think you want to get legal help, we really do encourage you to go and speak to an attorney. As we mentioned, prevention is always better than a cure. Whether you speak to us or someone else, we hope that you find the situation that find a resolution to whatever problem you're thinking about or decision that you're looking to make. For our particular services, Tzedek has kind of two main ways that we help people. And I just want to highlight that we set aside time once a month on the fourth Tuesday of each month to provide appointments for people to speak with an attorney and also a housing counselor about anything that they are facing that may put them at risk of foreclosure. That can be anything to do with property taxes, your mortgage, or anything else that results in a risk of foreclosure, like a PACE lien, for instance. If you'd like to get an appointment at our clinic, we encourage you to sign up online. We ask for a little bit of information so that we can determine your eligibility and also do some research to maximize our time with you. Lastly, this is the first in a series of presentations that we'll be offering. If you have any requests or suggestions for future presentations, we invite you to email us at the link on your screen. And with that, thank you all for your time.